Hi, I'm Alexis D'Alessandro. I'm a licensing associate at the Technology Licensing Office. For those of you that aren't familiar with the TLO, we work with MIT inventors to help move technologies from the laboratory to the marketplace. So for this video, we're collaborating with the MIT 100K competition to bring you some intellectual property considerations that you're going to want to think about as 100K competitors. So in this video, we're going to talk about three main points. First, how do you know if you're using MIT-owned technology? Second, what are some important IP considerations that you're going to want to think about as competitors? And finally, what is the approval process for teams that are going to be using MIT-owned technology in the 100K? So I think the first question that we're going to want to consider is, am I using MIT-owned technology? So it's important to remember that the owners of the inventions may be different from the people who are listed on the application as an inventor. For example, MIT owns inventions according to the MIT IP policy. If you have any questions about the IP policy, you can refer to the Office of the Vice Chancellor's guiding principles. But some common scenarios where MIT owns student-created IP is when it's done as part of a research or teaching assistantship, when it's developed as part of a sponsored research project, when you're making improvements to existing MIT-owned IP, such as patents and copyrights, when it's developed with significant use of MIT funds and facilities, and in other scenarios on a case-by-case basis. If you have any questions about whether the technology that you're using should be owned by MIT, feel free to contact our office, and a licensing officer will talk to you about your specific situation. Next, we're going to think about some of the IP considerations specifically for 100K competitors. So the first question is the technology sufficiently protected to allow you to make a public disclosure? Secondly, is the technology available for licensing? And finally, is my PI aware of my plans to commercialize the technology and participate in the 100K? So we're going to go through each of these different considerations kind of point by point and give you a little bit more detail about some of the things that you're going to want to watch out for. So the first question, is the technology sufficiently protected to allow for a public disclosure? So this is an important question to consider because a patent application has to be on file prior to a public disclosure in order to avoid the loss of patent rights. Once this patent application is on file, it's generally okay to publicly disclose what's being described in the application. However, I will add the caveat that it's really important to know what content is covered in the application and to only publicly disclose that content. Updates made after the initial filing to the technology may not be covered in the original application. So you're going to, again, want to talk to the appropriate licensing officer to get an understanding of what's covered in the patent application and what you can publicly disclose. I'm going to go now into a little more detail about what the criteria for a public disclosure is so that you know if you're making a public disclosure, both in the 100K competition and in other places where you might come across it in your day-to-day life. So the two criteria for a public disclosure are that they need to be public, meaning it's available and accessible. So this could be any non-confidential communication of an invention to an outside person. And the second criteria is that it's an enabling disclosure. So that means that it describes the invention in a significant enough detail that someone reasonably skilled in the art can reproduce the invention without undue experimentation. So looking here, we have kind of a matrix of what may or may not be considered a public disclosure. So some things that are clearly public disclosures are journal or thesis publications, thesis defenses, and something that's public like the MIT 100K competition. Up here in the top left corner, we see the abstract is available publicly, but is not necessarily enabling, so that might not constitute a public disclosure. And things like presenting at an MIT-only group meeting is probably enabling, but is not public enough to be considered a public disclosure. Again, we always recommend you come and talk to us if you have any questions about whether a presentation or anything that you're submitting might constitute a public disclosure. The second consideration is the technology available for licensing? So there are a couple of common situations where IP might be unavailable for licensing. First, MIT might have certain obligations to research sponsors to give them first rights to license the technology. Secondly, particularly for some older technologies, it may have been previously licensed or it might be in active negotiation. And finally, the IP might be background IP for ongoing research projects, which means there might be certain limitations on what MIT is actually able to license for the technology. And again, you're going to want to talk to your TLO to understand what licensing options might be available for you, but you're also going to want to consider which of these licensing options is the best fit for your business model. And finally, you're going to want to discuss the 100K competition and your startup plans with your PI. PIs can be great resources and can help provide guidance on how to manage conflicts of interest with MIT research, other commercialization and research plans they may already have for the technology, and help to connect you to resources available in the MIT and Boston entrepreneurial ecosystem. Both the TLO and your PI are really great first people to talk to help you achieve your startup goals. I'm going to move now to the steps that you're going to want to take if you're a team that's going to be using MIT-owned IP and participating in the 100K. So before applying, you're going to want to talk to your PI about your plans to enter the 100K competition. And you can use some of the points that I brought up as guidance for talking to your PI. Then, if you're advised by your PI, you're going to want to disclose any potential IP to the TLO. And you're going to want to indicate on your 100K application that you'll be using MIT-owned IP. If your team is accepted as a finalist, you will be receiving a form called the 100K IP information form, where we're going to get some additional information about your team and the technology that you're planning on using, which will help us to triage and get you connected to the appropriate technology licensing officer. You'll then meet with this technology licensing officer, and they're going to give you a sign-off on using the IP in the 100K competition. So they're going to talk to you about a lot of the aspects that we discussed today, if the IP is available for licensing, if you're able to make a public disclosure, and help to clarify any additional questions that you might have. And then finally, after you get sign-off from the correct licensing officer, you're going to return the completed IP approval form to the 100K organizers, and that's how they're going to know that you're able to use the IP and all of these different considerations have been followed. If you have any additional questions, feel free to reach out to the TLO at the email address specified here. And I've also provided some links to our invention disclosure form, guidance on IP ownership and managing conflicts of interest, because I think these are some of the frequently asked questions. Thank you for your time. We're really looking forward to working with you, and best of luck on your 100K application.